Today, we're going to be looking at those amendments which are made to CPR 44.14 by virtue of the Civil Procedure Amendment Rules 2023, and then we'll be following up in relation to some costs cases in relation to qualified one-way cost shifting that have come out over the last 6 months or so. In relation to those cases, we'll be looking at issues relating to mixed cases. So what happens when your personal injury claim is struck out, but the balance of it carries on and is determined by the court? Is it appropriate to disapply qualified one-way cost shifting when a claim is discontinued? We'll further be looking at what period qualified one-way cost shifting applies to, where a personal injury claim is introduced only part-way through the proceedings and isn't contained in that claim from the outset. We'll be asking whether you can lose the protection of quox where a Part 36 offer is accepted out of time. Also looking at whether quox is automatically disapplied or can be disapplied where a party is legally aided. And finally, we'll be looking at whether you can effectively bypass the provisions of qualified one-way cost shifting and seek a third-party costs order against a claimant's solicitors or the receiving party solicitors when it comes to the detailed assessment proceedings. What is the position then in relation to set-off? Because that brings us neatly on to the consideration of this cost change. So in proceedings which were issued before the 6th of April 2023, then we had the Supreme Court decision of Hohner-Delikan back in 2021. And again, in the circumstances of a claim, which we don't have sufficient time to go into today, but previous videos, I believe, are available and it will be covered in some Learn Live seminars. The jurisdiction to direct set-off under Rule 44.12 is not displaced by the qualified one-way cost shifting regime, but in claims to which qualified one-way cost shifting applies, CPR 44.14 doesn't allow the court to set off cost liabilities per se without regard to the prohibitions on the extent of enforcement. So while costs could still be set off under CPR 44.12, qualified one-way cost shifting still existed or exists, and therefore that set-off could only be up to the total amount of the level of damages and interest. So as per the final bullet point that you'll see on the screen, a defendant can recover the costs ordered by any means available, including set-off against an opposing costs order, but only up to the monetary amounts of the claimant's orders for damages and interest.